Hello, everyone. Ooh, my hair. Um, Thanks back for our afternoon session. I don't think this should take too long. We have a few items to check off. The first is to approve the minutes from our last meeting. Um, can somebody, I move to approve the minutes. Can somebody second that?
Second.
Anybody opposed? Okay. The minutes from our last meeting are hereby approved. Now we're going to have a quick presentation from Rick about the failure to protect homicide cases.
All right, cool. Everybody can see my screen? All right. Well, yeah, so we're going to talk about failure to protect homicide, which we heard a few of the panelists lift up today, um, and which is a specific type of murder liability that allows parents who did not actually kill their children to be convicted of their murder if they didn't do something, take action that was reasonably, possible for them to do. We saw from Debbie's and Andrea's fatal peril report that I think it was about 14% of women in their survey that were convicted of killing their children. We don't know how many of that group was convicted under a failure to protect theory, but they said that that was certainly something that came up for them. And we know that in these cases, IPV dynamics are often at play, and can be considered. Failure to protect liability is a form of accomplice liability. The committee discussed accomplice liability for murder at its October meeting. You may remember that this is an
I'm
area.
sorry, Rick. Sorry to interrupt. Can you just give us like a really quick example of what would be a failure to commit scenario? Failure to
A
protect.
failure to protect.
Yeah.
Oh, sure. Yeah. So one of the cases that was kind of mentioned today a few times is the Collins case, where the defendant, Brittany Collins, was convicted of killing her 2-month-old son. Her abusive partner, the child's father, had actually committed the killing while he was in another room and Miss Collins was in a different room of the home. There was evidence that he had abused her in the past that was actually used against her as proof that she knew how dangerous he was. But in that case, even though she didn't participate in the killing herself, the argument that she went to trial and lost on and was convicted was that she failed to meet the standard of a diligent parent. More specifically, that um, parents are required to take every reasonable step to prevent their children from suffering harm.
Okay. Got it.
Yeah. So again, this is a form of accomplice liability. Accomplice liability for murder is something the committee discussed at this October meeting. And you may remember that this is an area of law where there's been a lot of development recently, particularly with SB 1437, Senator Skinner's bill that eliminated accomplice liability, or excuse me, eliminated murder liability based on the natural or probable consequences doctrine and the second degree felony murder rule. And then after that, there's been more recent court decisions that have kind of further clarified other standards that are used in those cases since those two doctrines have been eliminated. Um, this and then there was this new case that came out just in January of this year, People v. Collins, in which it was the first California Supreme Court case to take on this particular flavor of accomplice liability for murder, this failure to protect standard post, the changes of 1437. Um, and in this case, the court offers a significant clarification of the standard that's required in these cases. Now that the natural and probable consequences doctrine has been eliminated, and so the court clarifies that liability for murder and failure to protect cases requires that the parent who's alleged to have failed to protect, that they actually knew that the other person was going to commit this dangerous act, and they knew it with substantial certainty. And it also requires that prosecutors prove that whatever they think the parent should have done to step in and prevent the action, that was actually something that had a high probability of preventing the harm. And in those determinations, the court kind of describes at length how IPV dynamics can be at play in deciding those issues. So this case represents a significant clarification of this particular area of murder liability. But like other things that we've looked at it and what was mentioned today, it doesn't necessarily provide an avenue for relief for the people who have already been convicted previously and that are serving a sentence. It doesn't provide resentencing or anything like that. And so the staff recommendation here would be to allow for habeas corpus relief for individuals who are serving a sentence based on a conviction that's based on a failure to protect theory, and that they, under the new Collins clarification, there's a reasonable probability that they would see a different result. This is consistent with other actions the legislature has
Right,
taken in the IPV space.
got it. I have a couple
Sure.
questions.
Sure. Can I
We
take this?
have no idea how many. First of
Professor
all,
Ocean put her hand up too,
oh,
Micah.
I'm
So
sorry. First of
I
all, I
know
keep on missing your hand. It blends in with your books. I miss your.
it
Ah,
does a little
Yeah,
bit.
it does.
yeah. Um, that's all right. I'll just keep my audio off when I raise my hand. I'll just connect. So I'm understanding, Rick, that the relief, the decision obviously is not retroactive, it's only prospective, right? And so there isn't, so I also want to clarify that the legislature hasn't enacted a statute that would render like these kinds of decisions retroactive without a specific statute that particularly targets this form of accomplice liability, right? So there's no statute that says like if the California, if the California Supreme Court renders, a decision that, fundamentally alters the, standards or the elements of a crime, others can, file petitions to be to have their convictions reviewed under the new standard. That's not something that we have in the state of California. Is that correct?
That's my understanding. Tom, do you agree with that?
There isn't a statute, but there is this very lugubrious legal test about whether a decision is retroactive or not. And I, you know, and I think, but I think that idea is a really good one. Let's not sort of have this be, I mean, it's always going to be contested, even if the statute, like what's a sufficient enough change. But we do see in the existing habeas corpus statute reference to like decisions, convictions for offenses before a certain date. And that date is when a big Supreme Court case came down. So, for a decision like this, you can tie it very specifically to this case, but a more general statute is really interesting as well. But part of me wonders if it's just sort of there's going to be as many fights about that as there are around the current test. But I think it'd be a really good step to at least try to narrow those fights down.
Mhm. Yeah, that was just the question I had. And do we know how many people and so just to clarify, we don't know how many people have been convicted under this theory.
No, I think the closest guess that we have is based on the fatal peril survey data that indicates that 14% of those individuals surveyed were convicted of killing children. Again, that data doesn't dive more specifically into the type of theories that they were convicted under. So we don't know, but Debbie and Andrea's interpretation was that that was a significant group of them, but that's all we know.
So,
But I think even with that, it's still overall a small number of
right.
people just
Mhm.
on an absolute scale. Yeah.
Is the failure to protect doctrine only apply in homicide cases, or can you get failure to protect
It
for?
applies across the board.
I think there's like a specific crime around failure to protect children, even if it doesn't result in a homicide. I mean, obviously there's child abuse, but I think that and it's obviously a standard that applies in the civil context with child removal statutes. So there's, the failure to protect kind of exists in a lot of different areas, not just in homicide. The other question that I had is, do we know how many people have been convicted, say, of first or second degree murder on a on a straight up, like not as a principal, not as as an accomplice. So part of what I'm asking is, so you could be convicted based on a failure to, an omission, right? With a culpable state of mind that result where there's a death that results, which wouldn't be an accomplice theory. That would be straight up
Mhm.
homicide. And so I'm wondering, are you also suggesting that there be some revision to those standards when the issue is, someone had a duty to act to protect a child, and they were, extremely, the theory is that they're extremely reckless or that they were reckless, and so that's either second degree murder or manslaughter.
Well, on the data question, no, unfortunately, you just see, conviction for first degree murder, second degree murder, and all the different theories that led up to it. It's all, there isn't a place for it on the abstracted judgment, I guess, is
And that's
the
true
way
for
to
any
think
other
about it.
crime too. Sorry to
Right.
interrupt, but just like any other accomplice liability crime, we don't know if a person was convicted as an accomplice or as a principal looking at data.
But I think
Is that something that we should suggest be collected by the Attorney General's office, or so that we can better understand accomplice liability in California if you're not clear whether the person was convicted as the principal? I mean, obviously the jury doesn't need to say one way or the other, but is there any way we could gather that information? Are there verdict forms, where at least was the theory was in the mix? Is there any way that we could better identify how this failure to protect is being used, either with regard to people as principals or with regard to accomplice liability? Because perhaps the number is so small that if it's like, you know, 50 women or 10 people who were convicted of killing their child when they weren't the primary actor, then perhaps we could dig into their cases and kind of get a sense of the trend. So I guess I'm just wondering, how can we better understand how this theory is being utilized?
I mean, is everybody's sense that these cases would all have gone to trial, or would they be plea cases, a large percentage of plea cases?
Probably more cases resolve in a plea than go to trial, I would imagine.
All
if
right.
you're facing murder, the plea will always be to something
Right,
significantly
no, of
less,
course,
right? So I think that
they're presented with the theory of failure to protect, so then they plead down to manslaughter. That's tricky. Because if they got to trial, then we could do the research.
Well, and the
well,
difficulty is that even at trial, like even in the Collins case, for instance, Professor Ochin, you might have a theory put forward at trial by the district attorney that this is accomplice liability for failure to protect, but there's also a direct perpetrator analysis as well. And even if when the jury decides, you don't know whether they convicted them as a direct perpetrator, whether their actions rose to that level and caused the death, or whether they were, so it would be whether they were an accomplice. So it's hard to ask courts to track that information because you don't know from the jury. It would have to be like some type of jury verdict form, which is like a more difficult battle. It makes it, I don't know, seems harder for the district attorney to prove those cases. The jurors have to pick what exact version they're going with.
but I think this conversation highlights for me too. We sort of think of this as kind of a medium level recommendation. It's not something that will necessarily affect a huge number of people or do anything more than just greater effectuate the change in the law to the extent there was one that the California Supreme Court did. But because these folks are convicted of murder of their own child, the harm is just so deep. Even if it is, I think, a relatively small number of people, it seems appropriate to give them the benefit of current law.
So it seems like we've moved into the conversation about recommendations, which was our next item of business. Just we've started with the habeas question, which is whether or not we should make a specific type of habeas relief for people who would have benefited from Collins. I think we should think about it. We all sort of seem to be circling around thinking about it some more. My initial inclination, for what it's worth, is to think about retroactive habeas relief for changes in law generally, not specifically to the Collins case, because as Tom mentioned, it is an extraordinarily complicated sort of doctrine that's unnecessarily so. And I think that we should all stand for the position that if you wouldn't be convicted today, you shouldn't be in prison regardless of what theory it is. And just because it's a substantive change in law, procedural change in law, or all the different analyses. So that would be my initial inclination. Collins may be a good case example, but that's my general thought. Any other thoughts on this habeas and Collins recommendation from the memo? All right. Going in order of what we discussed today, the first thing that we talked about was modernizing the statutory definition of self-defense, particularly in IBV cases, and particularly the idea of imminence. I think that, well, I'll speak for myself. I think we should definitely make a recommendation on updating the definition of self-defense. Along the lines of what I had just said about the habeas case, I wonder if we should limit it to IPV cases, or if it just we should generally update the idea of self-defense. As Rick wrote in the memo, the original rules on self-defense were from cowboy times, I mean, literally, and seem really, really outdated and problematic. I think that they come most to the fore, or they're highlighted, particularly in IPV cases. But anyway, and particularly around this idea of imminence. I don't know if other people had thoughts or wanted to comment.
Yeah, so I agree with your inclinations around habeas having sort of a general statute rather than one specifically around Collins. And with regard to the self-defense statute, this is where I'd be interested in Assemblymember Bryan's thoughts. I would be supportive of a recommendation that is, generally applicable rather than specifically for people with intimate partner who have experienced intimate partner or domestic violence. But I do, again, this is where I'm interested in Assemblymember Bryan's feedback, which is, what is the easier path to enactment? So if we start with intimate partner violence around the self-defense standard and then later expand it, I'd be fine with sort of sort of more sequential approach to it if it's a easier path, because this is the area where I think there's so much pressure on the doctrine. But I will say, in terms of the broader sort of the general applicability of the revision to the self-defense standard, I think that would be more in line with, like, for example, what the model penal code does. They don't have, I don't think there is an imminent standard in their recommended approach. So it might be good for us to look at what the model penal code advises. I think it's sort of like if someone was reckless in their assessment of the need to use deadly force, then it's more like manslaughter, so it's an imperfect self-defense or negligent or something like that, without the like imminence or I think there's a necessity standard, and then there's like a state of mind standard in terms of how someone is assessing the situation. And I'll look that up real quickly, but I think there is some support for expanding it generally. In other words, I think it's right in terms of like reality, and I think it's also right in terms of the trend in law. But I do wonder, is it right in terms of the politics of the legislature? That's my question.
Yeah, I mean, so there are lots of issues with California's self-defense law, including ones that, I think the committee would sort of change in the other direction if we started to look at them, around like stand your ground and some other racial issues
I was
with
gonna
those
say,
laws.
are you aware of what went down this year around on that side of things?
We followed it a little bit, Rick Joy and I.
Where Kyle Rittenhouse offered to come to the committee on the Public Safety Committee?
It looks like he wasn't given that opportunity for different reasons. Yeah.
The bill was pulled. I think to Professor O'Shin's comment, I think anything intimate partner violence, has an easier pathway. and it's harder to argue against. But I think I'm, similar to what Tom was bringing up, I'm a little confused where the legislature is on, self-defense because of that backlash. And for folks who don't know, there was a bill by a colleague of mine, um, uh, kind of recognizing that adjustment that needed to be done and stand your ground in pulling some of that back in line with what's happened in other states here in California, and just got lit up, blasted, absolutely annihilated digitally and social media and far right wing press, and then probably made some ill-advised comments that triggered Kyle Rittenhouse directly, who offered to come and testify against the bill. The bill ended up being held or pulled in the first committee. And so to me, that that leads that if you're increasing self-defense protections, the ability to assert self-defense in certain cases as a defense, I think it's an interesting moment.
So, first of all, I think that there's consensus, at least to continue to explore this issue and to continue. I think Professor Ochen's advice to look to the modern penal code in particular. Rick, did you look at that, by the way? Did you look at the modern penal code on this?
Yeah, we looked at the model penal code in some other states as well. And as kind of mentioned in the memo, different sources have defined imminence differently. And so that kind of shaped our recommendation to kind of modify, how that's defined or considered.
I think a solid definition of eminence. I didn't agree with the DA that the evidence code allowing in IPV evidence was sufficient to expand that. So I think that we could work on that. In terms of how much we consider the politics, we've always kind of balanced that. On the one hand, I want to think that we're a committee that just makes the best recommendations, period, and leave it up to the lawmakers to pick and choose what they think. But on the other hand, I don't want to be completely unrealistic. So I think that's just something we're gonna have to struggle with, continuously.
Well,
But
and
go ahead.
and here's also, I guess, a more principled reason to be hesitant about sort of expanding eminence globally.
Mhm.
And this is something you see in some of the discussions in the self-defense standard is, what would you do like in a gang case where a lot of guys will say, look, as soon as I see someone from a rival gang, there's a risk something bad is going to go down. It doesn't have to, I don't have to be about to be shot. That was imminent enough. And there'd be similar arguments about the risk of fear alone. It's like, I feared myself, but you also have, maybe other considerations there. And I think there may be a way to, so I think just expanding imminence global, without any other changes is tricky. And you can imagine other situations too where beyond that one. So that's why I think we really focused on these cases where we have a really solid evidence base. There's an issue, it's gone unaddressed for way too long, and this fix would seem to directly address some of the issues that we found. And I'm personally very hesitant to reach out larger into these issues without a lot more study. And as Assemblymember Bryan mentioned, there's a lot of other stuff in the self-defense code, including the only real change to it since 1872 is a presumption that if you shoot someone breaking into your house, that's self-defense. So it's very tricky. Of course, that's why we're here. That shouldn't stop us, but that is a little bit of why we came to this conclusion that sort of let's just start in these cases where we're on really, really solid ground.
And just on that point, in terms of starting with intimate partner violence cases, like how would the statute be triggered? Would it be that the defendant would put forward sort of like a prima facie case that they were survivors of intimate partner violence, or that there's this evidence is present, and then sort of just like this standard self-defense, and the burden of proof would shift to the prosecution to disprove the elements?
Yeah, that's how we think of it.
Okay.
All right. Well, I think we have some clarity here on at least moving forward and helping to try to refine how we would amend the self-defense law. I don't want to foreclose the idea of moving it beyond, but I hear your points, beyond IPV cases, but I hear your point. The second item is that to allow habeas relief to retroactive, if should the self-defense law get changed to, and I think that we're in agreement that that should apply retroactively along the lines we were talking about before with Collins. All right. The next is how and whether to clarify the coercion defense to include factors, for example, the length of time between the alleged abuse and the offense, whether the defendant was financially dependent on their abuser, and whether or not how important documentation of prior abuse should play into the analysis. Rick, is there anything more to?
I would just say that it's important to think about these factors as just giving kind of guide rails for judges and practitioners to begin to make this decision. You heard a lot today that there's a lack of training, there's a lack of understanding, and then they're confronted with the statute that says, if an offense is a direct result of IPV or human trafficking, make the decision. And so the idea is to establish some framework and statute that says, here's what you should be thinking about, but not to be an all-inclusive list, and to make sure that it says including but not limited to, so that sure, you could consider documentation, but it's not required.
No. I think we all understand including but not limited to. People have thoughts?
I'm just pulling up the memo so I can be direct. So would we also give guidance on like other testimonial evidence, like, statements to friends or family, or, areas where people are more likely to share what's going on as opposed to like a police report or medical report?
Absolutely. I think the recommendation that we have in the memo is just kind of a starting point, and the idea would be to further develop the specific factors that we might want to add to a statute. I mean, there were some today that were mentioned about, attempts to leave a partner in the past, whether you've been stalked, tracked, or kidnapped, whether there's been a threat to harm children or challenge custody, whether you were choked, whether you passed out. I mean, all of those things could be potentially added as things for courts and stakeholders to consider in making this decision.
But how you prove that is always challenging
Yeah.
for any of these defenses. So I think that's a bit difficult for us to solve. But yeah, we consult with Jamie and other experts too to come up with a real list, a good list.
I don't have a strong feeling about this one. Peter, do you have a thought?
Had to unmute.
Sorry,
I think it's worth looking at. I mean, I don't have a strong feeling either, but I think it's worth looking at.
And
Okay.
also,
Yes.
are we, when we're talking about coercion, are we using the language of like coercive control? And I know that that's something that's utilized in like the restraining order context. So, there are some judges that understand, what coercive control is. So is that kind of the approach that we're looking at with this language?
Again, I would say that I think that's something that you could add as a factor to be considered. Right now, the statute says for the affirmative defense, it kind of leads with, as Jamie pointed out, the offense was committed due to coercion. And so she identified that as a problem. I think, you could, as she suggested, remove that part from the statute. Also, as maybe you're suggesting, add some definition to what that means, including coercive control.
Yeah, because looking at the definition in the memo, it's physical as a direct result of physical or sexual violence, and we know that coercion is much broader than that. Like the things that you're talking about, controlling communications, controlling money, controlling, who you see, who you can be in the company with, that sort of thing. I think it should be broadened to include that kind of again, coercive control, which is very common, and certainly is recognized in the family court arena as a form of intimate partner violence.
I like incorporating language from other areas that we think is good. So in terms of consistency, and I think that makes a lot of sense. Any others on this? So the direction to staff is to continue to explore this, how to clarify this area with these definitions. Okay, the next on our list is to somehow prioritize clemency review of IPV cases. We talked with Justin Dews about this, about whether or not the legislature should sort of even dip its toe in here, to the extent that our recommendations are sort of to both branches. I suppose we don't need to necessarily make a legislative recommendation. I think I support his idea that legislative prioritization of clemency cases is an area that I might not want to go down, but I don't know if other people have thoughts.
He convinced me. I think this is a hell of a bipartisan letter to the governor, but I don't know that it's legislation.
Well, and maybe I can give a little more context to just sort of the state of play right now too. And obviously, Mike, you know a lot about this. Is currently the Board of Parole hearings has the power to both sort of start its own clemency investigations and also to do one when the governor asks for one. There are 0 to very few regulations around that process, but I believe the governor has announced that he's asked BPH, and BPH is working on regulations to sort of, give those things some more process, and maybe who's eligible, when will people be reviewed for clemency. So this recommendation could be, as you said, Mike, not necessarily requiring, a policy bill or anything, but something that should be part of that regulatory process. Or if we think BPH isn't the right vehicle for this, because when I heard Mr. Dews speak, there seemed to be like some value to, like, this is sort of a limited time kind of strike force almost vibe to a little bit. Like, we have a very discrete mission. We have experts to do it. And we're going to do it in this amount of time. And that, might inspire action where, people are doing a very long sentence or life without parole. There's really no impetus necessarily to move quickly on cases. And the other reason thinking about clemency here is, obviously we had the Board of Parole hearings and parole hearings for folks with indeterminate sentences, and we had some data about this in the memo. There's a lot of folks, and we had just data on women in prison who are doing, life without parole or a long determinate sentence who, don't have any other opportunity for earlier release.
So I have a couple thoughts about that. So, Priscilla, sorry.
No, I mean, it seems to me that and I appreciate the role of this committee and the work that we do on the penal code as a whole, but it just seems like this issue does require more of a systematic approach. Like, we need to look from top to bottom how gender-based violence, traumatic brain injuries, ACE scores, like all this really relevant information to, how folks exist in the world, and the experiences that they have and the harm that they cause, right? It's super relevant, but there isn't always like a place for it in the penal code. And so I would just make a suggestion, given that we have a really lovely member of the legislature here, if there were a committee that could look at this specifically and come up with a comprehensive, sort of omnibus package to really, ensure that there is appropriate consideration of, intimate partner violence, traumatic brain injuries, ACE scores, these things that really bear on people's ability to make healthy choices for themselves and others, right? It's relevant. And the other thing that I would suggest is, we had talked about something analogous to like a racial justice act, but one that speaks to gender. I think that could be a vehicle for addressing the multiple touch points that we've been hitting on. So if it's about, the commenting on, discriminatory frameworks, or, the exclusion of certain kinds of evidence, or the use of, you know, uh, culpability from an abuser, to impute the guilt of the survivor, right? These are all areas where we want comprehensive review. But if we go at it, a little bit at a time, it could take a decade, right, to really do this. But there could be a more comprehensive way to approach it, either through basically the equivalent of a RJA, but for a gender, or something that is more focused, like a specific, set of legislatures that present a comprehensive bill that addresses it from, arrest to charging to sentencing to, um, parole. And there's already a lot there in these areas, like parole and, vacature and so on. But on the front end, it seems to me that there's a lot of work to be done.
I couldn't agree more. I like the idea of thinking of a Gender Justice Act. It's a big pill to swallow to try to encompass everything that you were suggesting there. So, in the interim for staff, first thing that I sort of think we missed, but I sort of liked, was can we just merely amend the Racial Justice Act to include misogynistic implicit bias along with racial bias and prosecute, just that seems like it might be just a few word uh amendment. I don't know. Think about that. Alternatively, or in addition to the sort of more global reform, I suppose that Professor Ochin was suggesting.
I think the professor is attuned, by the way, to the appetite of the legislature. I think something like there is heavy appetite for something like more so than at any time since I've been here. In fact, women in the criminal legal system in that intersection and incarceration has become a priority of the Women's Caucus more broadly. We've got new legislators who are prioritizing this section of the criminal legal system and the penal code, trying to figure out what does it mean based on their past history as prosecutors in these areas. I think guidance from this committee in a very heavy way in terms of a Gender Justice Act or some sort of recommendation like that would be very well received by the legislature. I think there's huge appetite, and I think there might be, I haven't spoken to him directly, of course, but I can see the governor also being very interested in trying to wrap his hands and redefine this issue, because I think, narratively, it's been such a very hard thing to talk about with the nuance and sophistication that it deserves, which has made it even harder to have kind of policy solutions. And so I think if there's a group that could put this together, it would be this group, despite the fact that there are way too many men on this panel, and we miss Senator Skinner every day.
Um, well, okay, well, we have a great model in the Racial Justice Act, so maybe we start there. All right. That is the end of our recommendations. Rick, did I miss anything?
The discussion around the clemency, I feel like we didn't quite
Oh.
close the loop on it. Maybe that's fine, but I just wanted to maybe raise that.
All right, so you alluded to these new regulations. So what's happening is the governor, I believe, has announced that there's going to be, that they want to, and this is something that we've been talking to them for a while, is regulations that would bring people who have very, very long sentences back to the parole board for recommendations by the parole board to give clemency or not. This has become popularized because of the Menendez brothers case, because this is the process that he has started for them. To date, the regulations have not been published. They've been promised. They prioritize people who have served very, very long sentences already. You could imagine adding to that intimate partner violence. I share sort of Tom's, I think what you were saying, some skepticism about really, does that get more cases to the governor's office? Perhaps yes, perhaps not, but that's a way that we could perhaps weigh in. Is that what you're suggesting, Tom?
Yeah, that's one avenue, or to just propose something outside of BPH, honestly, because there have been there are existing regulations and some statutory authority that when there is a parole hearing, they're supposed to consider intimate partner violence, typically as a reason to grant parole, but it doesn't. And this was some of the work Debbie did before, and others at the Stanford Criminal Justice Center did before their current report. That doesn't really seem to be happening. Of course, all those cases are very complex and fact specific, and the parole standard is what it is. A clemency advisory board can, might actually be a feature, not a bug, that it would be more of a black box. I think it's worth. We just wanted to sort of present it for discussion. If folks aren't interested in pursuing it, that's great.
Professor Ochin.
No, I'd be interested in hearing more about the clemency project process. I was also sort of thinking about the part of the memo about vacature. Sorry to change the subject, but my understanding, and I'm sorry that Heidi's not here, is that this has been a real challenge. That folks don't have lawyers.
Right.
There isn't like even a form. There's stuff happening all over the state that's different, and so I think. And I don't know that it's one of our recommendations. It's something that was highlighted in the memo, but there's no recommendation regarding vacature relief other than expanding it, which I agree is important. But if no one can use it, then expanding it isn't particularly helpful. So I guess I'm just questioning what, if anything, this committee can do to make vacature a more practical remedy for people, because if you're seeking vacature but you don't have a lawyer, is it really a remedy? If you are seeking vacature but the courts don't have a process, even if you do have a lawyer, is it really a remedy that's usable? So that's the question I have: is what recommendations can we make to improve the vacature process for folks that are already eligible, but have not been able to utilize this remedy?
Well, I think that what we heard about vacature from staff as we were researching it is that, yeah, it's not widely used for some of the reasons that you mentioned. And then even in the places that are kind of lifted up as places where it's used the most, that in a lot of cases it goes forward as an agreement between the parties where they're not, having contested litigation to decide whether somebody should get vacated or not. I think, and what we also heard is that it's up to each kind of judge and each district attorney to be able to have a lens to interpret whether an offense is related to IPV or not. And in some places, that's better than others. Some judges are better than others. Some district attorneys are better than others. And so that's one of the reasons we thought, as a next step, one of the ways to get stakeholders to use this law more and to use it more consistently is to identify some of the things that they should be looking at in deciding whether it's directly connected to IPV. That more guidance, more understanding of that across the board would help to train everybody who's making these decisions on what exactly they're supposed to be dealing with. It doesn't address attorney funding or anything like that, though. So that is a limitation.
Have public defenders gotten any funding to do vacature work? Because I know it's largely fallen to nonprofits who mostly work on like trafficking to do this work. And obviously trafficking is encompasses a lot of intimate partner violence, but not all of it. So unless you're already connected to an organization that focuses on this area, it's difficult for you to get relief. So maybe that's a question, whether there should be allocated funding for pro bono, for either uh, public defenders, or maybe some initiative from the governor's office to get pro bono counsel to represent folks who may be eligible for vacature. Obviously, that's not necessarily, the latter isn't necessarily something that we can control, but if someone from the governor's office is watching this, I think that would be a great idea. Yeah, so that's my big question, is like, how do we get folks to use it? So I think giving judges something more to hang their hats on, and to clear, to sort of like, focus argument would be good. And I also think it would be good if we could figure out like how many people have filed these petitions, how many have been granted. And I think if we looked at it over the last few years, I think we'd be surprised at how low the rates are. So I'd love to get that information if the California Policy Lab has access to it.
We've tried, no one has it. We've looked in the place where it would be as a disposition, and it just doesn't appear, unfortunately. And
Is
the
there a reason
anecdotal,
why not?
I mean, I think all of these records are in disarray to some degree, and the stuff that gets put in most diligently is what's going to be relevant for a future arrest or prosecution. What were you convicted of, and why? So yeah, and Rick spoke to a lot of folks trying to get it anecdotally, and that confirmed exactly what you were saying, Professor Roach, and it seemed to be intermittent usage. I also wanted to go back to the question sort of about funding for attorneys. That's been, and obviously some member Brian will correct me if I misstate anything, sort of an ongoing dynamic with the legislature and the governor giving money to public defenders for all the hosts of sort of resentencing reforms. And I think there hasn't been quite a agreed upon approach to that, and with the budget challenges the state is facing, that probably is not going to improve anytime soon. Of course, there should be attorneys for all these folks, but I think that's relevant to some of these discussions.
Sorry, just the last question on the attorneys thing. Are judges able to appoint counsel for cases that they think are particularly meritorious?
I don't believe there's any provision in the vacator statute specifically for that.
I think that always makes me really excited, even in a down budget year, the idea of codifying, and we've done this before in this committee, codifying authority to do things when it's unclear whether you can or can't, and some may or some may not, but highlighting that you can and you have the explicit authority in the penal code to do that, to the extent that that's interesting at all to this committee. It's definitely something we've done before that's been found useful in areas where it's unclear.
I second that, or third that, or whatever. I think that's a great idea. I'm less interested in directing funding, and I think that runs a little bit beyond our jurisdiction, but I like the idea of.
I know somebody who's got a bill right now that would gut them in for this idea because it's a great idea. But I'll save that for post discussion. But I think that's I think what the professor has mentioned is important and does touch on the budget constraints and the concerns, and just the parity between prosecutorial funding and defense funding in general. But I think in this vacature space, empowering judges to be able to appoint counsel if they feel it's meritorious, I think that's incredibly powerful conversation.
And back to my previous comment about we should be recommending what's good policy, whether or not it's financially or politically. I'd rather err on the side of recommending good policy and let legislators pick up.
Well, the local governments will see this as an unfunded mandate, and that's going to be the complaint about it. But I agree. Let's codify it and see what happens. If somebody has to pay for it. So, I mean, it won't be the court out of their budget. They're talking about laying off staff, and so the county will be next in line, and they'll have something to say about it. But I think we should definitely codify it. And I just have a question before we move away from clemency. If I'm understanding this concept of clemency, it's one way to address all of these LWOP sentences that we're concerned about. And so if I'm understanding that, then I'm in favor of trying to regulate and make it more accessible to folks that are serving long sentences.
That is the proposal. Although we've been promised it, and they went to the newspapers about it, but nothing's come out yet.
Right. It seems to be in progress through the Border Patrol hearings right now, but the timeline is, unknown.
Sounds like progress is lugubrious.
Well, I think there's been more progress than ever on it. Let's put it that way. So if, and I think everyone is acting in good faith, obviously. So
there's also a brand new head of the parole board, which I think is probably, we should be just conscious. In fact, we should probably have him.
Yeah.
Our guests.
I invited them. Well, I obviously gave them a heads up about our discussion today, and they're in the middle of I think a big BPH multi-day meeting. So,
all right. But and just in general, Jennifer has been useful to us, and we've really cared about parole. And Scott, we should get on his radar as well.
Judge Espinoza, while you're unmuted, I wanted to ask you, just for, as a judge, this case that we heard Professor Babcock talk about, where like a semi-nude picture of the defendant was displayed for the whole trial. If that had been presented to you, I mean, obviously we don't know all the facts and everything, but it seems like you would have had the authority to say, no, that's not going to happen in my courtroom, but there's nothing also forbidding it.
Yeah, it's called more prejudicial than probative. And I think in a lot of courtrooms that would have not been allowed.
Right.
It's just, I don't know what the evidentiary value of it was, how it was presented, but yes, a judge could have easily excluded that photograph.
Right. And and this is something Rick and I talked about too, in sort of preparing, everything for this meeting, is we do have what are often called rape shield laws that do prevent, sort of gendered evidence coming on, of a certain type, and maybe it's worth exploring a similar approach to some of the things we heard about today that would kind of tie in with the Gender Justice Act discussion. Well, so we'll add that to our to-do list. I'm just thinking out loud a little bit. All right.
I'm sorry, I had a little glitch there. Are we ready to move on?
I think we're ready to conclude.
All right, sorry I missed that last 2 minutes. All right, thank you. It's been another great productive day. Thank you especially to the staff. Thank you to the committee. Thanks to our loyal audience who has stayed with us today, and to all, of course, all the panelists and our guests. It's now time for public comment. If anyone is here, well, I don't think there's anybody in person. Correct me if I'm wrong. But for those of you who are listening on Zoom, to get in line to comment, please select the raise hand function in Zoom. If you're calling in, you can hit *9. Please note that this meeting is being recorded. If you make a public comment, your name and/or phone number may be displayed as part of the recording. We'll take a minute now to see how many people want to comment, and based on that, we'll decide how much time each person has to comment. Please note that the committee accepts public comment in writing, and in fact, that's a preferable way to get in touch with us substantively. With that said, let's please get in line.
We got Jane Courant.
I see that. Hello, Jane. Why don't you take 2 minutes and tell us tell us what you're thinking.
Hello, everyone. I am really disappointed that I had a conflict and missed your morning session, because the panel looked very interesting to me. As you may know from my prior comments, I am a member of the California Coalition for Women Prisoners. I communicate with several women, including a couple of trans women, and I am also involved through CCWP with the Drop LWAP Coalition. And I communicate with about 6 or 7 men with life without parole. 3, 4 of them have been in for 40 plus years. One of them, a published poet who's quite prominent out on the internet, had just celebrated the 50th year of his imprisonment. That's probably not the right word. So, although I just have heard the discussion and none of the panels, I am really pleased. I was thrilled to see that you were covering all of this today. And I know that I think the self-defense work that you're talking about initially to be gendered really makes sense. The people that I know, and just from having been a member of CCWP for several years, heard the preponderance of women accused of murder were abused. And as far as the issue of coercion in accomplice crime, convictions, that is also just a very, very important issue. So please do continue along the lines you're speaking. Those who have heard or read in the newspaper or heard on television who are incarcerated with LWAP, we're very excited about the governor's announcement, and certainly hope that whatever this committee is capable of doing to push that initiative forward would be most appreciated. I appreciate you all. I'm very thrilled that Congressman Bryan is in office doing the wonderful work he does. And like he said, I too miss Nancy Skinner, and another female voice, particularly from the Senate, would be terrific for the committee. I don't know where membership stands now, but just wanted to thank you. And I'm going to look forward to listening to I understand there'll be a video, so I can listen to the panels. And yeah, just keep at it.
Thank you, Ms. Grant. Yes, we'll post these on YouTube. I don't know how long it takes to get up online, but not too long afterwards. So
and Heidi and I are, we're carrying the banner. We're doing
yes, exactly.
And we're very lucky to have Senator Weiner, I think, from the Senate too. I think I just want to say that.
we are. And Anako Jefferson. Am I pronouncing your name correctly?
Oh my God, I didn't know what to expect today, and I stayed on like a stalker the whole time. Being a crime survivor and just looking at that thin line of becoming on the opposite side, being a dual survivor, and I start thinking of some of my family members and people that I work with that have been impacted by horrendous violence and have become a dual, become a survivor. And then because no one paid, listened to them, they become a defender. I mean, become on the opposite side. And I really appreciate Priscilla, talking about African American women, because that's where I see a lot, and how that's kind of swept under when they have to defend themselves, and how when law enforcement comes out. So thank you for bringing that up. And then also Heidi, just kind of like following the work, but I think having the survivors on, so so people can see that how our voices need to be heard. And sometimes people think, as a crime survivor and the violence and things that has occurred in our family, we are standing strong and advocating against the system and some of the things that you're talking about in the penal code and changing. I want to see those changes. I'm not in the frame of mind that punishment, lock the keys, lock everybody up. And so I do support Drop LWAP. I do support the campaign for the fair sentencing of youth. And then also our organization, Jira Shalom, we do the restorative work dealing with the DC sniper, and even having being a part of that case, and even advocating and watching the how the Supreme Court will always use, when they're looking at juvenile lifers, Lee Melville's case. So the work, I've never seen this type of collaboration. So I am just so thrilled that you guys are all working together in the diversity of having people from all the backgrounds, because we always just hear a lot of times as survivor people who are punishment focused. So thank you so much. And then also, I just noticed I got a thing from I'm trying to remember that they're cutting the funding for the people that are being sexually abused and services in prison. So I think that's crazy that that funding is going to be cut. I don't know if anybody has heard about that, about them taking that funding away. You know, that funding is being cut for those voices and those resources. So I don't know if that's been something that's looked at and investigated on why that's been taken away. And then one more quick thing before I get off. When someone was talking about adding about I think I'm trying to look at my notes, dealing with trans, putting something, I can't remember who was talking about revising, dealing with the racial issues, adding in something to that. And I'm probably misinterpreting it, but I was saying if we could keep that separate so stuff doesn't get lost in when we're talking about race and gender, keeping things separate so stuff doesn't get all lost, because sometimes when one law is made for one group of people, that person who it was made for, sometimes the focus isn't on them anymore. It begins to be everything that's sub and under. So thank you so much. And I am leaving here just really interested in digging more as a survivor in the penal code changes. So thank you.
Thank you, Ms. Jefferson. Thank you to everyone. I had heard that there's been funding cut from the Prison Rape Elimination Act, which is a federal grant program to study and help prevent violence behind bars. I think that's part of the Trump administration's effort to reduce federal spending, especially in causes like this. I don't know much more about it. In any event, I think that's the end of our public comment, which marks the end of our meeting. Thank you all for your time and attention today. Our next meeting is Friday, May 23rd, where we'll expect to discuss judicial disqualification under Code of Civil Procedure 170.6. But in any event, thank you all. Please be in touch if you have questions, especially by email. I look forward to seeing you all in different capacities and on the 26th. Have a good evening and a good weekend.
Thank you.